This case starts like a routine arraignment, and then it spirals fast. We're talking masked suspects, stolen bank cards, surveillance footage from multiple locations, and a defendant with a criminal history stretching back nearly 4 decades. What begins as a suspicious person call turns into a multi-victim theft investigation with video evidence, eyewitness confrontations, and a judge who is clearly not buying what the defense is selling. Stay with us, because by the end of this hearing, the bond decision alone will leave you stunned.
Later determined that that lawnmower belonged to the resident at the fence, the area the caller had seen the subject tampering with earlier. At 6:40 a.m., a second caller called and said that he found a purse hanging from his fence. He checked it and saw that it belonged to his neighbor, who would be victim number 1. Officers contacted victim number 1, who said she was missing several bank cards out of her purse. At 7:53 a.m., victim number 1 called Riverview Police and said that she was alerted her cards were being used at Kroger in Southgate. While officers were on the way to Kroger, victim number 1 called back and said that she, along with her husband, had drove to Kroger and located the suspect, who they described as a white male wearing blue jeans, a black and red jacket, exiting Kroger with 2 full shopping carts of merchandise. Victim number 1's husband then confronted the subject in the parking lot, who abandoned his carts and fled north through the...
Pause right here, because this is where the case quietly gets serious. Officers don't just find a suspect description, they find physical property linked directly to the scene. A bike hidden in bushes. A lawnmower traced back to a resident. This matters legally because it establishes proximity, opportunity, and intent before a suspect is even identified. And notice the timeline, everything unfolds within hours. From the masked individual fleeing to stolen cards being used in real time, this isn't circumstantial fluff. This is a clean chain of events prosecutors love.
A lot on foot. As victim number 1 was following the suspect, he was retrieving objects from his pockets and throwing them. Victim number 1 lost sight of the suspect and then went back to retrieve the object he was throwing, finding them to be the bank cards that she was missing, along with several other bank cards belonging to a second victim. Officers were in the area looking for the suspect when Chief Allen of Riverview Police saw a white male wearing blue jeans and a blue sweater quickly walking east from the location on Quarry Road, north of Pennsylvania Road, in the city of Wyandotte. Chief Allen saw the male cross over 23rd Street and then proceed go into a residential property, where he then jumped the backyard fence into Wyandotte Memorial Park. Officers from surrounding agencies were able to catch up with the suspect, who was then apprehended and identified as Michael Larsenese, the defendant in this case. Larsenese matched the original caller's description and partially matched the description victim number 1 gave, the only difference being the jacket color. Larsenese was placed under arrest for suspicion of larceny and transported to RIPD. Among his possessions in Larsenese's pockets was a small screwdriver, flashlight, $10.47 in loose change. He also had $201 cash, a new pack of menthol cigarettes, and 3 lottery tickets. As part of this investigation, I was able to determine the owner of the other bank cards in the city of Riverview, which is a short distance away from victim number 1 in the same subdivision. Victim number 2 was missing his entire wallet from his vehicle that had been parked unlocked in his driveway. His wallet contained several bank cards, including the ones that were found in the Kroger parking lot. Victim number 2 checked his card activity and found that a $100 charge happened at Marathon gas station on Pennsylvania Road in Southgate, and an attempted $400 charge at Kroger in Southgate that was declined. I was able to get video of both these locations, Marathon and Kroger. Marathon video shows a white male matching Larsenese's description, wearing blue jeans, black and red jacket, and a blue Detroit Lions hoodie underneath. His hood is pulled up and he's wearing a white N95 style face mask. He also has on distinct tan hiking shoes. The male in the video goes to the lottery ticket machine and purchases several lottery tickets, which he then scratches and presents to the teller. $150 in cash winnings is given to the male. He uses $20 to purchase an additional single lottery ticket from behind the counter. The male then scratches the ticket, presents it to the teller, who then gives him additional $100 in winnings, for a total of $230 in cash after the $20 purchase. The male then purchased a pack of menthol cigarettes and a Red Bull and left the store. This total is consistent with the amount of money Larson...
This is where things cross from theft into bold audacity. 2 full shopping carts. Stolen bank cards. And then, the victim personally confronts the suspect in the parking lot. That's risky, emotional, and incredibly rare. When the suspect dumps the carts and runs, throwing bank cards as he flees, it becomes visual evidence of consciousness of guilt. Ask yourself, if you're innocent, why abandon merchandise and scatter evidence behind you? This moment alone dramatically shifts how the court views credibility.
Larceny was found with, which was $201 cash. Kroger video shows the same white male with the same clothing at a self-checkout at 7:15 a.m. The mail goes into several different pockets, as well as what appears to be a black person fanny pack, retrieving many different bank cards and attempt to use them. Several are clearly identifiable as belonging to both victims, which he eventually dropped in the parking lot while fleeing. The male leaves Kroger with 2 shopping carts of merchandise on video and confirms victim 1 confronts him in the parking lot where he then flees, corroborating victim 1's statement earlier. Larceny's Merrill brand hiking shoes, blue Detroit Lions jacket, blue jeans all match surveillance video footage from Marathon and Kroger. And his possession at the time of his arrest, including the small screwdriver, flashlight, large amount of loose change, $201 cash, new pack of menthol cigarettes, 3 lottery tickets, support Larceny's being responsible for these crimes. Larceny's has an extensive criminal history dating back to 1989, including felony convictions for receiving and concealing stolen property, possession of a financial transaction device, identity theft, illegal sale use of transaction device, and his most recent felony.
Here's the legal nail in the coffin: surveillance footage that matches clothing, behavior, and most importantly, money. The lottery ticket purchases, the cash payouts, the cigarettes, even the exact dollar amounts found during arrest. This is what prosecutors call corroboration across independent sources. Video doesn't lie, and when financial activity aligns perfectly with what's found in a defendant's pockets, explanations get very thin, very fast. Would you believe this was coincidence or a calculated spree?
Felony conviction in 2024 for felony controlled substance possession. He also has many other misdemeanor convictions that include larceny, B&E vehicle, and retail fraud. Larceny also has several warrants for his arrest with different downriver communities. And as a final note, I will just say that Detective Haskin from Riverview PD is working on a case involving 3 victims that occurred on 3/16/2025 in the same subdivision area of Riverview, case number 25-2812. During the investigation for this case, Larceny's was identified through video as being responsible for Lowe's larcenies as well. Detective Haskin will be sending his investigation for that case to the Wayne County Prosecutor's Office for review shortly.
Thank you. Upon examination, plaintiff there's probable cause to believe defendant committed those offenses. And counsel?
Thank you, Your Honor. Good afternoon, Your Honor. John Goldfall, P. 30758, on behalf of Mr. Larceny's. Mr. Larceny's, would you please put your name on the record?
Michael Larceny's.
Okay, well, counsel, as to the arraignment.
As to the arraignment, Your Honor, I've had an opportunity to discuss this matter with Mr. Larceny's. He would stand mute. He does have an extensive criminal record. He is not on probation or parole at this time, from what he's told me. Just indicating that the last case was resolved back in 24. He's self-employed. He no longer lives in Wyandotte. He lives with his sister. I'm not going to stand here and say, please give him a personal bond, which he asked me to give him, but something that is commensurate.
Okay, so Mr. Larceny's, how long have you been residing with your sister in the course?
About a year and a half. No, about 3 years. I'd say year and a half.
Sir, I think that you were residing in Wyandotte at your last court date that you had here.
I'm sorry?
Weren't you just here last year?
No, ma'am.
23. Oh, 23. Sorry. Have you changed your address with the Secretary of State?
No, I haven't. I was just waiting for my license to expire, honestly, because it's just coming up this year, and having to make the appointments and all that, and transportation issues. But I have given that information to every legal matter I've associated myself with.
Well, sir, I have to tell you, I think you have the thickest file today. You have cases that go back to 1989
Correct.
that are dealing with theft, sir. 1989, we're on almost almost 40 years. Almost 40 years, sir, of criminal history regarding theft.
Okay. I've
Don't say anything regarding this case.
If you were to test right now, sir, what is in your system?
I would just like a personal bond, Your Honor, so I could try to pursue my legal matter of owning a lawn service where I'm trying to make money legally.
I can 100% guarantee that you are not getting a personal bond.
Well, could you get it as small, as low as possible, please?
My question to you, sir, was if you were to test today, what is in your system?
Nothing.
He has been incarcerated. He's been in jail approximately 3 days, right?
Okay. And what happened with your matter from 23 from this court, sir? When you were bound over to circuit court?
I don't recall. My time served.
Oh, okay. Well, you weren't on probation?
I was, and I completed it in the time served. It's closed. Case is closed.
Well, October in Trenton. Well, wait a minute here. In October of 23, you pled guilty to felony. Actually, it was August 1st of 24 is when your probation was set to start. Felony identity theft out of the 33rd District Court. Felony financial transaction device illegal sale or use. And that was 18 months probation.
It's all been closed, Your Honor. It's all been closed.
That's been closed already?
Yes, ma'am. I've completed it and closed it. I'm on no probation.
Early discharge, right?
I don't know, it's been 9 months. When did you get, when was your probation concluded, sir?
February of this year, I believe.
6 months. Wow. Interesting. And then now, you're suspected in another matter that's under investigation, and now you have these 16 counts. What, is that funny, sir?
I'm not guilty of these 16 counts. I'm sorry, but
Well, sir, tell me about your probation from Third Circuit Court for felony possession of narcotics, where you were sentenced to 3 years probation. How is that already closed?
it's all been closed, Your Honor.
Has it been closed because you violated probation and they revoked it and you said you spent time served?
Yes, ma'am.
There we go. There we go.
It's all closed.
Okay, well, you led the court to believe that it was closed because you successfully completed it. But clearly, you violated probation.
This is the moment the room shifts. A criminal history dating back to 1989 isn't just a bad look, it legally matters during bond decisions. Prior convictions for identity theft, stolen property, and fraud make these new charges feel familiar rather than accidental. Judges aren't punishing past crimes here, they're assessing risk. And with multiple open warrants across jurisdictions, the court is now weighing one question. If released, will this defendant come back?
It was revoked, and then you were sentenced to incarceration for that. So, sir, you're being a little bit disingenuous with the fact that you're saying it's closed and completed. It's not completed. You didn't complete it. I'm sure it shows revoked probation, not probation closed without improvement. And you have a number of warrants for your arrest, sir. Why is that?
I don't know about the warrants.
Detective, do you know where the warrants are? Hold on, maybe I have them right here. I can tell you. I'll tell you right now, sir. Let's see. 23rd District Court from April of 24. You failed to appear for an arraignment pre-trial.
What's the charge?
Possession.
Okay.
Then in 2023, you did not appear for your possession of heroin in the 25th District Court. Then April of 24, oh, this was the second one for this, so.
Misdemeanors.
Whether they're misdemeanors or not, sir, you still didn't show up to court. So.
I understand.
There's a misdemeanor.
I'm just taking stealth notes, Your Honor. I'm not.
Excuse
To the
me,
court.
keep your mouth shut.
Then we have in the 24th District Court, January of this year, you failed to appear for court on your possession of drug paraphernalia. Oh, just last week, you were supposed to have been in 23rd District Court,
For what?
arraignment pretrial.
For what?
I'm not sure, it doesn't show what it was for, sir.
Your Honor, it says obstructing police, I believe, for that one.
Oh, that's a,
Oh, there it is, obstruct police, yes, okay. So, sir, I have to tell you, the board has some serious concerns for the safety of the public, as well as your ability to return to court. Detective, would you like to address bond?
Your Honor, I think just because of the harm he's the harm he's caused to the city of Riverview's residents in this case, and not only likely the case in March, his extensive criminal history, obviously a history of not showing up to court. I would ask.
This exchange is brutal and telling. The judge catches inconsistencies in how the defendant describes his probation history. Closed doesn't mean completed, and the court makes that distinction crystal clear. Violated probation followed by incarceration is not a success story, and the judge isn't letting wordplay slide. Credibility matters in court, and right here, it collapses. Once a judge believes you're being evasive, every request after that becomes an uphill battle.
$25,000 cash bond, as well as if he is able to make that bond, electronic monitoring through the tether system in Wayne County.
yeah.
Mr. Larsenis, you seem to be making a lot of noise while the detective is speaking. I'm not sure if that's sighing or chuckling or what that may be, sir. In addition to your criminal history, the court has 34 entries of cases in this court going back to 2006. Possession of paraphernalias, loitering, larcenies, possession, driving while license suspended, interfering, reckless driving. Okay, so here's what the court's going to do. The court, after hearing from counsel, hearing from Mr. Larsenis, hearing from Detective Herrick, reviewing the criminal history, the extensive criminal history, the number of times that Mr. Larsenis has failed to appear in court, failed to complete probation, and given the court's concern with the safety of the public, this court is going to order a $250,000 cash bond. You're not to have any contact with any of the complaining witnesses in this matter. And you, in the event you post bond, you are not to be released without GPS tether house arrest through the Wayne County Jail.
Your Honor, would the court at least consider the amount I'm not quibbling with, but would the court at least consider a surety?
No.
With that cash?
The court will not consider a surety because Mr. Larsenis has shown that he is unable to appear in court, as well as the fact that he has 4 aliases as well.
Just
and now
asking
we are
you.
here at 16 counts of charges that are similar in nature to ones he was just convicted of last year, as well as littered throughout his criminal history. And what is that, Mr. Larsenis?
Thank you, Your Honor.
What is that, sir?
I'm not guilty of none of this.
Well, now you'll have to.
You guys are calling me guilty, and I'm not even guilty.
Oh, sir. No, sir. I've heard.
It sounds like you are. You're coming at me as if I have done this. I have not done this.
Sir, I have heard evidence that has been put forward that supports probable cause to believe that crimes were committed and you have committed those offenses. Based upon that, the court.
Picked out of a crowd walking through a field.
Like the
You know,
arraignment.
now they looked at my record and said, yes, this is him.
And
Be
the court
quiet.
also taking into account your criminal history and your.
I've already did my time for them. Why is that used against me again? That's illegal.
Sir, that's not illegal. That is a factor.
Yes, it is.
That is a factor that this court is required to take into consideration when determining bond. And in this case, your criminal history is so significant with the same types of charges that you're currently charged with, that this court has concern for the safety of the community. So that is the order of the court.
Thank you, Your Honor.
Have a good day.
Thank you, Your Honor.
When prosecutors ask for a $25,000 cash bond with electronic monitoring, that's already significant. They're signaling danger to the community and risk of flight. But listen closely, even that recommendation doesn't fully capture how concerned the court is becoming. Failure to appear, multiple aliases, ongoing investigations. This isn't about punishment anymore. It's about containment. And the judge is clearly preparing to go much further than anyone in this courtroom expects.